I've been asked if a corporate entity or business entity provides protection for me. What is the purpose of me getting insurance or bond protection? Well, corporate entity protection does not do the work that insurance and bonding do. When a entity is formed, it could be an LLC, it can be a corporation. The liability shield that comes with the entity protection is a default rule of your business structure. The veil that it provides, and we call this the corporate veil, just think of it as a shield. The veil that it provides can separate personal assets from being touched, but it does not fund someone's legal defense if a claim is brought against them. It does not protect the business from the people running it, and it is not absolute. The statutory shield, the statutory veil, and the D&O insurance and fidelity bond are three layers that can apply to a business, and each one protects a different party against different risks. So should someone get the additional protections depends on their circumstances, but I'll share with you the different ways in which they all work. So the corporate veil, the shield, as I stated, is the default legal rule that's provided by establishing a business entity. If you read your state statute, it will read something similar to members, managers, and officers are not personally liable for their business debts by reasons of their status or for acting within their official capacity. So that protection is legit, but it protects against ultimate liability. It does not protect against being taken to court. The shield does not block a lawsuit from starting. So an officer, a director, or manager can be named individually, even after acting in good faith and doing nothing wrong. To trigger the shield, this protection, the corporate veil, that person still has to enter into litigation and prove that the protection applies. And entering into litigation is a cost. That defense costs the entire time. Director and officer insurance or D&O insurance funds that fight. The protection for individuals who act in an executive capacity for an organization can carry a risk, or who carries a risk, of legal liability for their actions operating in that capacity. And D&O insurance covers the ongoing defense costs and settlements when an individual is targeted personally. So those costs come out of a policy instead of out of their personal savings, especially when the company, because some people might say, well, why isn't the company covering it? When the company cannot cover the loss, someone has to pay for the defense, or covering that defense may be restricted from an indemnification clause between that director and the company. D&O insurance also can help with preventing piercing the corporate veil. So in certain situations, remember the veil is what protects you, protects your personal assets from the business assets. Well, a corporate veil can be pierced when corporate formality, or put another way, when rules on how to function in your business to keep your personal and business separate, when that formality has been abused, and there's different elements that a court will look at, a court can disregard the entity entirely and impose personal liability on officers and directors for corporate obligations by piercing the veil. However, in some jurisdictions, the court won't even analyze a corporate veil piercing analysis if the corporation maintains liability insurance. If a corporation has liability insurance and they maintain that for a certain amount of insurance to cover the business, and the business is sufficiently capitalized, a court won't even pierce the corporate veil. So both the corporation protection that's given by statute, through the statute, and the D&O insurance is not unconditional. State statutes and standard insurance policies apply strict exclusions for certain conduct as well. So any type of behavior that falls within these exclusions can sit outside of being shielded or covered by the policy or the statute. Just as important, policy coverage is governed by the specific language, terms, and exclusions that are written into the insurance contract. So it's important for you to understand the type of insurance that you are getting and what those terms and conditions are. And an operating agreement. An operating agreement governs how an entity operates. And if the operating agreement has terms and conditions written in it that's different than the default rule of the statute. Because like I just read earlier, what the default rule of most states are, if the operating agreement has its own way, it can override the statutory defaults that I mentioned earlier. So protection may be lost just from the terms and agreements and operating agreements. So it's important to know what an operating agreement says and how you all, the owners, establish an operating agreement for their business. And lastly, a bond or a fidelity bond. It points in a different direction and it needs its own lesson. But what I will talk about here and what I believe you should know is that it protects the organization from internal theft and dishonesty. It does not shield the individual from liability. It covers the entity against the people inside it. And it's not always optional. D&O insurance is generally optional. It's a choice generally, but for officers, fiduciaries, and managers in specific institutional contexts, federal law requires a bond to safeguard the trust assets that they handle. Understanding that each layer protects a different situation, a different party, and that the documents and the conduct decide how far each one will reach can be the difference between having a business and running a business. If you formed an LLC or a corporation and assumed that the entity absorbs everything, this lesson is for you. You can book the legal strategy meeting to talk deeply via Zoom or phone call, whatever is your choice, about the protection that each of these layers can offer your current structure, or that your current structure actually needs, or where limits may fall before a claim ever lands in your lap. Understanding what your business needs happens in the legal strategy meeting. However, if you already know what you need, but you want to know how you can secure ongoing trusted protection, you can book a complimentary 15-minute inquiry call. The link is in the bio or description for both. Until then, I want you to keep learning with the Ownership Attorney.